Hi class, my name is Heather Johnson, and forgive me for my stuttering. I'm super nervous about doing this, but I want to give a shout out to my cameraman, Nicholas. As I said, my name is Heather Johnson, and this is Healthcare Ethics and Medical Law course at Ashford University with instructor Jeff Kingsbury. In Week 2, Discussion 2, I am the defendant, AU Hospital, who is being sued by plaintiff Jennifer. AU Hospital is a public hospital, and in the response to a subpoena not accompanied by a court order, AU is accused of impermissibly disclosing the protected health information, PHI, of one of its patients, Jennifer. Contrary to the privacy rule protections of the information sought for administrative or judicial proceedings, the hospital failed to determine that reasonable efforts had been made to ensure that the individual whose PHI was being sought, Jennifer's, received notice of the request and/or failed to receive satisfactory assurance that the party was seeking the information made reasonable efforts to secure a qualified protective order. The Health Insurance Portability and Accountability Act, HIPAA, of 1996 provides for certain legitimate disclosures of PHI that do not require written authorization from patients. These exemptions include disclosures of PHI in order to facilitate medical treatment of a patient. They may disclose it to another health facility, for example, for the transfer of one patient to another facility, transfer of a patient from one facility to another. They may disclose PHI for payment, insurance, or billing, as well as other healthcare operations as outlined in the regulations. There are also times when there is a chance for low-risk HIPAA violations that are exempt from breach notification. First, good faith, unintentional acquisitions, access, or use of PHI by a workforce member or a covered entity or business associate. For example, a staff member receives and opens an email from a nurse containing protective health information about a patient that the nurse mistakenly sent to the staff person. Maybe they inadvertently disclose to another authorized person within the entity or business associates. For example, a nurse calls a doctor who provides medical information on a patient in response to an inquiry. It turns out that the information was for the wrong patient, such as an event would not be considered a breach. It could not reasonably have retained the data. For example, a nurse hands a patient a medical report but quickly realizes that that's someone else's report and requests its return. In this case, if the nurse can reasonably conclude that the patient could not have read or otherwise retained the information, then providing the medical report to the wrong patient does not constitute a breach. AU regrets the release and strives to keep patient health information private and confidential. However, as stated, with the combination of low risk and legitimate disclosures allowed in the Health Insurance Portability and Accountability Act, AU was either unable or not required to seek permission from the plaintiff before the release of her personal health information. My resources were DMIX 2010, No Harm Done, Assessing Risk of Harm Under Federal Breach Notification, the Federal Law, the Federal Act of Health Insurance Portability and Accountable, HIPAA Act, and then our course Bustillos, D of 2013, Health, Ethics, and Medical Law. Thank you.